Now we're going to discuss two more cases before Judge Kahn in the Northern District of New York. Both cases were filed by my friend Shawn, who I've known for years. Here's what happened. He was hired by PM Veglio LLC, doing business as Paul Mitchell, the school, to do work in Florida. He had a signed contract that was signed up here in Schenectady. Went to Florida. Throughout the whole process, they kept asking him different things. They changed the things and he kept billing them for them. But they wouldn't pay him for the extra work. Finally, at the end of the thing, he walked off the job because he hadn't been paid what he was required to be paid according to the contract at that point. Plus, they had all the back work or other work that they asked him to do that he also hadn't been paid for. It was a lot of money, and he couldn't afford. He couldn't even buy more materials because they weren't paying him what he was entitled to. So after he left the job, he came home. Doesn't a company named Von Curtis Inc. file a lawsuit against him in Florida claiming he violated a contract when doing the work for PM Veglio LLC. Well, the contract was between PM Veglio LLC and Shawn. Those were the only two parties named. There were no other parties in the contract. So Von Curtis comes in and sues him and makes all these outrageous claims that were totally false. Well, as soon as he got the complaint from them, and the first one of the arguments he made was he wasn't properly served according to Florida law. So they did not have personal jurisdiction over him. He also argued that the court didn't have subject matter jurisdiction because Von Curtis Inc. had no right to sue him because he didn't do any work for Von Curtis Inc. They did not have standing. The law on standing. Standing has been equated with jurisdiction of the subject matter of litigation and has been held subject to the same rules, one of which is that jurisdiction of subject matter, thus standing to bring suit, cannot be conferred by consent. Well, there was nothing in the paperwork saying anything had been sent to that Von Curtis Inc. had any interest in the contract. Absolutely nothing. All that was attached to the first complaint was the contract. And it didn't have anything to do with Von Curtis Inc. Standing requires that a party prosecuting the action have a sufficient stake in the outcome and that the party bringing the claim be recognized in the law as being a real party in interest, entitled to bring the claim. Well, if they had nothing to do with the construction, matter of fact, Shawn says he never even heard of them until he got sued. But they are tied in. PM Veglio is some way connected with Von Curtis Inc. But Von Curtis Inc. wasn't a party to the proceeding and their name's not on it. List a multitude of motives presented to the lower court by the appellant that clearly makes this argument numerous times. Therefore, it can be construed the lower court did not have jurisdiction of subject matter as to the complaint that commenced the action at the outset of the case. The complaint was devoid of any subject matter for the lower court to rule upon, bind its ruling upon the appellant, or move forward with the case at bar. The lower court could not have granted the sole movement, Von Curtis Inc.'s motion for leave to file amendment, as the outset of the case if the lower courts did not have jurisdiction of subject matter as the movement did not have standing. Well, what they did was they go into court, he raised it, and he did record the conversation, the court proceeding. It's a joke. Believe me. He was getting railroaded from the day he walked in there. Standing has been equated with the jurisdiction of subject matter. Well, they had no subject matter. What they did is, the judge says, oh, go and make an amended complaint. That'll cure the problem. No, that doesn't cure the problem. At the inception of the case at bar, Mr. Campbell, the attorney, never demonstrated anywhere within the complaint, within any subsequent papers filed or to the trial court during the first hearing on April 1, that the lone moving party, Von Curtis Inc., had even a casual interest in the contract. He just filed a motion to amend. Under federal guidelines, states, the Supreme Court has made it clear that the burden of establishing standing rests on the plaintiff. In other words, Von Curtis Inc., they have to prove they have standing. At each stage of litigation, from the initial pleading stage through summary judgment and trial, the plaintiff must carry the burden. Standing must exist on the date the complaint is filed. Von Curtis had no standing on the date the complaint was filed. And throughout the litigation, they never obtained standing. Matter of fact, Shawn was never properly served. The judge granted their motion to amend the complaint. What happened? This was also covered up by the court down there and Judge Kahn. They filed the amended complaint. The judge gave them 10 days to file it and serve Shawn with it. And they had to file a copy of what they filed the papers with the court of the amended complaint that stated that this was a true and complete copy of what was going to be served and filed with the court if the court granted the permission. Guess what? They completely changed it after the court granted their permission. Not only did they change it, they filed it like 25 days later instead of 10 days later. A completely different one, not the one that was approved by the court. And again, Shawn was not properly served as required by Florida law. Mr. Campbell, within his response to appellant's motion for rehearing in blank, clearly states in part, Douglas' arguments might have more merit had there not been an amended complaint filed and had the and the amended complaint not been served upon him. As I stated, they weren't properly served. It was not the amended complaint approved by the court. But again, standing must exist on the date the complaint is filed and throughout the litigation. He has just admitted, their attorney, that they didn't have standing. That's why he filed the amended complaint. So they didn't have it when it started. It should have been booted the first day it went into the court down there. What happened was, after, as soon as we had the suit up here, or they served Shawn up here, not only did we respond to this, but he turned around and filed a suit against them in Florida, against P.M. Vaglio at the Paul Mitchell School of Oviedo for the work that he had done and hadn't gotten paid for. So as soon as we filed that, we tried to get that transferred up here because the court down there had no jurisdiction and was refusing to address the issues of standing, whether Shawn was properly served in New York State, which he wasn't. We fully documented everything, what this law in Florida requires. They didn't do any of it. The court didn't care. You know, and then he goes on, Mr. Campbell, in his standing was conferred to Von Curtis within the amendment. This is blatantly false, as a party must have stayed to file at its inception and may not remedy this defect subsequently obtaining standing. Federal practice. Finally, plaintiffs must demonstrate for each claim and each request for relief. Well, they couldn't prove any claim because they were never part of the contract. Shawn never even knew of Von Curtis Inc. until afterward. And what else was funny, also on the amended complaints, they still had Von Curtis listed in there as a defendant, even though they admitted they had no standing. Or they admitted he wasn't part of the contract. Federal jurisdiction. Every person who under color of any statute, ordinance, regulation, or custom or use, or any state territory, subjects or causes to be cited any person or other person within to the deprivation of any rights secured by due process is a right, a constitutional right. He's being deprived. He's being sued by somebody he never did work for. Federal courts have a duty to entertain solid claim of unconstitutional restraint by state under color of its law, and jurisdiction of federal court is not defeated by anything which may occur in state court proceedings. Where fundamental civil rights are issued, federal court should not hesitate. Where there is deprivation of constitution, federal court to use injunctive power. Okay, the first order from Judge Kahn. It says, we were also asking for injunctive relief to get it transferred up here from Florida because the Florida court did not have jurisdiction over the issues. Then he writes, bars federal court from enjoining a proceeding in a state unless that injunction is expressly authorized by act of Congress or were necessary to aid in its jurisdiction or to protect or effectuate its judgments. Here's case law, stating the federal courts most certainly have the right to do it. He didn't care that Shawn's rights were being violated. He could care less. The next order by Judge Kahn. Affidavit that Veglio, he asked them to submit Veglio because he also lived in New York and down there. He asked Veglio to state where he resides. Veglio stated he resides in Florida. He has a Florida driver's license and has a residence down there. So, because all the defendants resided in Florida, Veglio was therefore to submit an affidavit regarding his domicile. The Veglio affidavit indicates that Veglio has maintained a Florida permanent residence and driver's license. The court is therefore satisfied that there is subject matter jurisdiction over this action. Now, because all the defendants in this case resided in Florida, he ruled that he had subject matter jurisdiction. That's very important because he contradicts himself. Then he dismisses the motion, or the defendant's motion to dismiss is granted. You know, he's not going to do anything, and he dismissed it after we also filed another federal suit naming the judges for not having jurisdiction because there was no standing, and they lacked personal jurisdiction over him. And it should have been dismissed at the outset, as we've just previously stated. Oh, here was an, I'll go, no, we'll see that. Now, in his next order, we have an order by Judge Therese transferring the suit Shawn filed against Judge Jordan and Paladina down in Florida because they were acting in complete absence of all jurisdiction. The case law is very clear. Where there is state statute or case law that expressly deprives the judge of jurisdiction, judicial immunity is lost. We've already demonstrated. There was no standing because Von Curtis Inc. couldn't sue because they were not a party to the contract. And standing has to do with subject matter jurisdiction. So they had no issue. They couldn't proceed with it, but they did. Related to other issues, he transferred it. Ordered. The above actions are to be noted as related, and each shall be assigned before the Honorable Teresa and Honorable Lawrence C. Kahn, Senior United States District Judge. Then Judge Kahn comes out with his final order. In the present suit, brought under 42 U.S.C. 19, plaintiff alleges that Florida courts' lack of subject matter and personal jurisdiction deprived him of his rights to due process and equal protection under the 14th Amendment. We did prove that, beyond a reasonable doubt. But they won't let you go to trial to prove it. You know, it's protect the other judges. Venue. All defendants have also moved under Florida federal rule to dismiss for improper venue. Plaintiff has not requested that if the court should determine, or the plaintiff has requested that if the court should determine that it is in the improper venue, that it be transferred the action to the district court for the Middle District of Florida. Now wait a minute. In his other case, he held because all the defendants in the other case that were not judges all lived in Florida, he had subject matter jurisdiction. And now he's saying because all the defendants reside in Florida, he doesn't have jurisdiction. I know, it's a head scratcher. All defendants reside in Florida. Therefore, a judicial district in New York clearly does not satisfy Section 1391B1 because no defendants reside in New York. Well, he just ruled that they did in the other one to dismiss it. A district court has the power to transfer an action to another district even if it lacks personal jurisdiction over the defendant. More generally, the court may consider whether transferring the action would promote expeditious and orderly adjudication on the merits. Each of these factors arguably counsels in favor of transferring. Transferring would expedite resolution of plaintiff's claims, and it would not prejudice defendants who all reside in Florida. Moreover, would force plaintiffs to spend a significant time and money filing a new action in new forum. The court nevertheless decides to dismiss rather than transfer plaintiff's action. Plaintiff shows a lack of diligence in choosing a proper forum. The law is you can't hold a pro se litigant to the same technical standards as an attorney. Shawn is not an attorney. He's a pro se litigant. You know, he's crucifying. Then he goes on to say, but rather straightforward application of the venue provision. Moreover, courts must take a peek at the merits. Dismissing plaintiff's complaint would be unlikely to survive a motion dismissed in a proper venue. In addition to jurisdictional grounds herein granted, defendants have raised significant immunity grounds for dismissing the complaint. They have raised them. But we have documented, there is case law, that they had no authority to proceed once it was shown that Von Curtis Inc., and by their own paperwork, wasn't even listed in the contract. A judge who proceeds knowing he lacks jurisdiction loses immunity. So Judge Kahn is trying to do everything he can to cover up for the illegal actions of the judges down there and put Shawn through more, what do you want to call it? I'll tell you, he was crucified. They had a closed hearing, they had a court hearing. He couldn't go down there because we documented how he recorded the phone conversations up here, which they didn't like. They were claiming he was illegally recording phone conversations. In New York State, As long as one person knows the phone conversation is being recorded, it's legal. Florida law, which we found afterward, holds that conversations made between states, and if the other state, it is legal in Florida. He caught them in a number of lies and a bunch of other stuff when he recorded the couple of hearings that he attended by phone, because he couldn't afford to travel between here and Florida for these 15-minute hearings, or a trial where they would have slammed him down. They weren't about to let him present any evidence to the court. Ordered. The defendants, Judge Jordan, Judge Palanis, Stevens, and State of Florida's motion to dismiss is granted. The defendant, Osceola County's motion to dismiss is granted. In other words, throw the whole thing out. They're violating the law. They're violating his rights. But that's okay, according to Judge Kahn. I'll tell you, after dealing with this, everybody should boycott Kissimmee, Florida, and Osceola County that it's in. You get caught there, you have no rights. They love the out-of-staters. Screw them over. He couldn't afford to hire an attorney to fight it down there. They had no standing. It should have been thrown out in the beginning. But this is how corrupt the judiciaries are. It's got to stop. And these federal judges are not doing their jobs. It's protect the corrupt judges and attorneys.